leading legal challenges with global business consulting. Operating a global business consultancy involves a high-stakes balancing act between delivering expert advice and navigating a minefield of conflicting legal systems. As a business consultant whose work transcends national borders, you are prone to encounter a labyrinth of laws where a single strategic decision can be perfectly legal in one country, while triggering severe penalties in another. The primary challenge for global business consulting lies in jurisdictional disharmony. While common law systems, like those in the US and UK, rely heavily on judicial precedents and flexible contracting, civil law systems, common in continental Europe and Latin America, are rooted in rigid statutory codes. For a consultant, this means a standard limitation of liability clause that holds up in London might be deemed entirely void by a court in Paris or Berlin, leaving the firm exposed to unlimited damages. Beyond contract theory, regulatory compliance serves as a constant barrier to entry. Many nations require consultants to hold local licenses or mandate affiliations with domestic firms to practice. In highly regulated sectors like finance or healthcare, a global firm must adapt its methodologies to satisfy diverse oversight bodies, such as the Securities and Exchange Commission in the US or the Financial Conduct Authority in the UK. Failure to align with these local nuances can result in unreliable entity designations, effectively banning a consultant from lucrative markets. Data privacy and sovereignty have emerged as the most volatile legal frontiers. With the European Union's General Data Protection Regulation setting a high bar, and countries like India and China enacting strict data localization laws, consultants can no longer use centralized global information technology systems. They must instead build siloed data architectures to ensure that sensitive client information does not cross restricted borders, a requirement that significantly inflates operational costs and complicates cross-border collaboration. Intellectual property protection also shifts dramatically across borders. In a consulting context, the work product is the primary asset. However, the legal definition of who owns a deliverable, the consultant or the client, varies by jurisdiction if not explicitly stated. Furthermore, in jurisdictions with weak IP enforcement, firms risk having their proprietary frameworks or digital tools pirated or misappropriated by local competitors with little legal recourse. International labor and employment laws present a radical departure from the at-will employment common in the United States. In most of the world, written contracts are mandatory, and terminating a consultant or staff member requires just cause and significant notice periods. Misclassifying independent contractors is another high-risk area. Many jurisdictions now use strict relationship authority tests that can turn a temporary consulting engagement into a permanent employment liability with backdated benefits. The taxation of intangible services adds another layer of complexity. While physical goods face tariffs, consulting services are hit with digital services taxes and complex VAT/GST requirements. Consultants must navigate a web of double taxation agreements to ensure they aren't taxed on the same revenue in both the host and home countries. Mismanaging these filings can lead to aggressive audits and the freezing of international bank accounts. Anti-corruption and ethical mandates, such as the U.S. Foreign Corrupt Practices Act and the U.K. Bribery Act, follow global firms wherever they go. A consultant operating in a region where facilitation payments are culturally normal faces a legal paradox. Comply with local custom and face criminal prosecution at home, or refuse and lose the contract. This creates a long-arm jurisdiction risk that requires robust, globalized compliance programs. Dispute resolution and enforcement remain the ultimate hurdles. If a cross-border contract is breached, the firm must decide whether to sue in local courts, which may be biased or slow, or opt for international arbitration. Even with a favorable ruling, enforcing a judgment in a foreign country is an uphill battle, often requiring the firm to locate and seize assets in a jurisdiction that may not recognize the original court's authority. Sanctions and export controls have recently become more aggressive. Governments now use services as fault lines in geopolitical struggles, placing export bans on high-end consulting related to AI or semiconductors. A global firm must constantly screen its client list against evolving denied parties lists to avoid violating national security laws, which carry heavy fines and the potential for criminal charges against executives. Finally, the cultural legal nexus dictates that legal does not always mean acceptable. Professional negligence in one culture might be viewed as a mere breach of contract, while in another, it could lead to criminal charges of commercial sabotage. Successfully navigating global consulting requires more than just legal knowledge. It requires an integrated strategy that treats law not as a static hurdle, but as a dynamic, localized risk that must be managed at every stage of the engagement. To learn more about our law firm's international business legal practice, we welcome you to visit our website or contact our law firm to schedule a confidential consultation. Thank you.